support the first reading of the Court's Remote Participation Bill and to advise the House that the opposition will be supporting its referral to Select Committee. Mr Speaker, I think that I want to make a significant, point about this piece of legislation, and that is the fact that it has a regulatory impact statement. Now, I actually don't understand why the government, who says that it's interested in regulatory reform, has decided not to have regulatory impact statements in their bills from here on in. And they've actually decided as a government to make sure that the regulatory impact statements are available online, but actually not where we need to see them at the time that we are debating the bill. So I want to commend the government on this bill and actually ask them to rethink their position on the regulatory impact statement, because I find these parts of the bill the most important when we are having debates such as this. Now, I know that the individual who's interjecting me knows more about this than anyone else, but the problem is that unless you've actually read the regulatory impact statement, what you don't understand is whether the analysis stands up. And I think that it's quite interesting that on this particular one, it certainly does, in my view, stack up. And I actually thought that members of the government would be quite pleased to find out that when you look at the cost-benefit analysis, that this one stacks up very well. But what I think is very interesting, and I'll be really interested in hearing the member who just interjected me then, you can obviously tell that I can't remember any of their names, no, that's true. That's right. I do remember his name. But the point that I was going to make was that when you look at the cost-benefit analysis on this particular piece of legislation, they've actually accepted a cost-benefit analysis that looks at future benefit, which I have never seen in any cost-benefit analysis that's been signed off by Treasury, and that's because this one hasn't been signed off by Treasury, it's been signed off by the Ministry of Justice. But it's a good step in the right direction, so I'm going to give it credit. Where credit is due, I think it ought to be given. What this particular cost-benefit analysis talks about is a monetary value which is assigned to the future. Reductions in costs for participants in the court process, improved efficiency for justice sector agencies, improved safety and security, increased access to justice, and improved quality of evidence. Well, I would say that that is a very good signal that we have in terms of the monetary value that, of course, can't be assigned specifically, but is obviously significant. And that's why I think that this particular piece of legislation has a lot going for it. Mr Speaker, the other thing is that in a regulatory impact analysis, it is important to look at whether there are alternative options. And they have looked at alternative options. And again, I think that this is a very positive document, and it is very useful in looking at what the options, what the alternatives were. Now, what the government looked at in this particular case was whether there were non-legislative options, and I think that's a good thing to do. I think one should look at whether there are issues that could be dealt with by way of guidelines, for example, and that was precisely what they did look at. But what they said was that non-legislative options were not an option in this particular case because guidelines cannot override or adequately clarify the legal status of the video links in all proceedings. Guidance on the use of ABL has already been promulgated, and it is appropriate that guidance such as this clarifies operational procedures for the use of ABL. The preferred legislative approach is outlined below. And I think that the point that they're trying to make, in fact it's very much like the debate we've just had on the previous piece of legislation, is that when you're dealing with such matters that relate to our court processes, it's absolutely vital that we have a strong legislative framework to back it up. And so this particular piece of legislation has created the option of specifying when AVL can be used, but also specifying when it can't be used, and then also creating a bit of a, I don't know whether I've got the right word, but whether there is a particular, I can't remember the word that I'm looking for. What I'm looking for is that there is whether there is a preferred outcome. So if there are a particular set of circumstances, it's going to lead to the use of AVL, so it will be automatic. So it's kind of like having a default provision to AVL, but in other circumstances not having that applied, so it will depend on the particular circumstances of the case. And I guess that the legislation's been designed to be future-looking, and I guess that means that there may be advances in the quality of the AVL options that are available in the future, and that might mean that rather than just looking at the procedural matters, that they will look at other matters as well. So I think that the legislation itself has been designed pretty well. It has been looked at in terms of its obligations to match the requirements with the New Zealand Bill of Rights Act, and it has been important to ensure that those options are there. Now, when one looks at the costs of having participants physically present at every single element of the process, then there are enormous costs involved, and this will obviously over time reduce those costs. Now, it is not just in relation to the costs of witnesses when they're required to appear in court, but it's also around the costs of transporting prisoners, housing them at the court, providing security, the average unit cost to transport and escort to a prisoner. All of those features of the current system are actually able to be addressed with respect to this particular proposition. When you look at the number of prisoners on remand and that expected growth, then obviously there is a flow-on demand for court appearances and associated prisoner transports. And at the same time, you've got then pressure on Defence Counsel arising from increased numbers of people entering the system, which has the potential to have an impact on consultation and preparation time. So all of these things add to the costs of the criminal processes, and so therefore this AVL system obviously creates significant benefit over the long term. In Australia, there have been a couple of approaches taken to the legislation in this area. The preferred option that was chosen for New Zealand was to have an overarching statute to apply across New Zealand legislation. The alternative option was to amend existing legislation, and the reason that that was not chosen, the alternative option, was that in a range of statutes they use varying terminology concerning participants in proceedings, and all of them would have to be amended to clarify whether participants could appear by AVL. And when you look at the range of legislation, the numbers of statutes that would have to be amended, the number of regulations, and then the number of rules as well, then it simply didn't stack up as an option. And I think that's why the government has quite rightly chosen the option of an overarching statute to apply across all New Zealand legislation, creating this presumption around the appropriate use of AVL, and that will apply to every part of the New Zealand law. So I'm very pleased that the government is taking these steps. I think it is appropriate that we look at the overarching costs and whether there are presumptions that could apply around the use of AVL AVL to the benefit of all those involved. So I do commend the government for undertaking this particular work, but I will make one point, and that is this, that representatives of the judiciary in their consultation have expressed support for the proposals, but they have emphasised that they see AVL being used predominantly in the procedural elements of courtroom proceedings and less so for the substantive components of proceedings where evidence is being physically presented. And I think it is important